Akila is a lawyer based in Chennai who has been on the faculty of the National Law University, Delhi, the National Law School of India University in Bangalore, and the National Judicial Academy, Bhopal. So do go ahead, Akila.
Thank you. Thank you, Prajnya, for having me. And let me share my screen. Yeah, so I've been asked to provide an overview of the Dowry Prohibition Act and related provisions of law. And I will keep to my brief and try to keep it short so we can have follow-up discussions later. By way of introduction. So in addition to the Dowry Prohibition Act, there are several other laws. So when it comes to legal remedies for dowry demand or harassment, I just want to set the larger context that there are civil remedies available that were available even before the enactment of Dowry Prohibition Act, which was in the form of divorce and other matrimonial remedies, general remedies under civil laws, and now after the enactment of Domestic Violence Act in 2005, you can ask compensation or injunction and such others. But the focus today is going to be on the Dowry Prohibition Act and related criminal law provisions that have been enacted for this specific purpose, that is the continued prevalence of dowry in society. So if we go to the context of the Dowry Prohibition Act, what the law says as its object and reason is, of course, that it's been several years and this evil practice is not going anywhere. So how do you come across a situation? They say, we tried to introduce more property rights for women, but that in itself was insufficient. So a law which makes dowry punishable was considered desirable. So the object was to bring about some kind of deterrent effect by making dowry a punishable offense. And the second object of this law, according to the text itself, is granting property rights over the dowry and vesting it in the woman for whose benefit it was given. So these were supposed to be the two sort of objects of the act. And at that point, there also was the initial attempt to sort of define it, saying, you can have customary gifts, but only up to 2,000 rupees. And then there was also a critique of that, saying, but does that justify and legitimize gifts up to 2,000 rupees, etc.? But that went off quite soon. But so how does the Dowry Prohibition Act actualize these twin goals? One of deterrence and secondly of ensuring that women get property rights and own the dowry that was given on their behalf. This is through Section 3, which makes giving and taking of dowry an offense. The punishment has been enhanced now to more than 5 years and a fine. Now, what is interesting to me when I read this is that the law seems to accord the same weight of gravity to taking of dowry and giving of dowry. So this law seems to be willfully blind to the larger context of dowry. Because when you read the provision as well, it would speak of dowry being, property or gift that is given to either party to the marriage. So they are being, gender neutral and context neutral now. And, the implication or the premise seems to be that giving of dowry is also a choice in the same way that taking of dowry is a choice. So, Section 3, which is one of the primary provisions in the Act, says any person who gives or takes or abets the giving or taking of dowry is punishable with fairly serious punishment. Now, of course, punishment is made more stringent over the years, and if the court wants to award lesser punishment, they have to give specific reasons to justify why lesser punishment than what is mentioned in the law is given. Uh, so as I was saying, the idea behind Section 3 is something that equates giving of dowry and taking of dowry. And this attitude also, was observed by the Supreme Court, where in a more recent, I think like a 2005 judgment, where they say, the evil of dowry will end only when brides stop giving dowry and their families refuse to give dowry. So this is a slightly skewed understanding of the larger social practice, which I'm sure the other speakers will talk about. So where there were attempts to amend the law saying that, giving of dowry need not be an offense. The sort of lawmaker said, no, this is going to be counterproductive. We cannot make, we have to retain giving of dowry as an offense. Coming next to the question of, okay, if giving and taking of dowry is an offense, what is dowry, right? Dowry is property or any kind of valuable security given before, at, or after the marriage. So even if it's a gift that is given before the marriage, during the marriage, on the day of the marriage, or after the marriage, if it is in connection with the marriage, whether it is given directly by the parties to the marriage or the family members or gifts through other people, this is dowry. And of course, we know that giving or taking of this is an offense. But what are exempted from the purview of dowry are customary gifts. And also the presence should be, and the property that is given should be in connection with the marriage. And this has caused sort of significant difficulties in interpretation. The one Supreme Court judgment, which interpreted dowry death, again, the definition goes back to this Dowry Prohibition Act itself, says, well, we understand that, gifts that are given before the marriage and during the marriage will more easily be called dowry. But what is gift given after the marriage, right? It is an unending period. And they say that, of course, there could be customary gifts that are given, for festivals, for celebrating birth of a child and different other ceremonies. And those customary payments will not be considered dowry at all. So this was a rather literal interpretation of the law that has led to significant difficulties, where you are narrowing down the definition of ambit. So if someone asks for gifts upon birth of a child, upon ceremonies after the marriage, say the first Deepavali or the first Pongal, for example, in Tamil Nadu, are where customary gifts are demanded, are given. Those customary gifts may not be considered dowry according to this interpretation. So, and another exception to dowry are presents that are given and which are maintained in a list in accordance with a particular rules that I will talk about just in a minute. So where these are customary gifts that are given and the value is not excessive, considering the financial context of the parties, these presents are not considered dowry. So when it comes to other offenses under the Act, not just giving and taking, but demand of dowry itself is an offense that is punishable. And like I said, the Act prescribes minimum punishments for most provisions. And if the court wants to award an even lesser punishment than what is prescribed, they have to specify reasons and record it in the judgment. So demanding dowry directly or indirectly from the parents or other relatives is punishable. Please sort of, I would like to note what I said earlier also about how the definition still is, kind of gender neutral and context neutral, which I frankly don't see the reason why it should be that. Section 4A specifies another offense where it says, any advertisement regarding dowry is also punishable. So if the family of a prospective bride, put in an advertisement in a newspaper or wherever else saying we will give X amount of dowry for this marriage, that is an offense. the newspaper or the media that publishes this and circulates this is also liable for punishment. Uh, this those provisions related to the first goal of the act, which was, deterrent effect of dowry by prescribing offenses and punishment. With regard to the second object of the law, which is property rights of women, we see section 5, 6, and 7 being relevant. Section 5 says that the agreement for giving and taking of dowry is void. So if at all, two families had agreed to solemnize a marriage, given certain dowry requirements, that agreement becomes void. It can't be enforced. Section 6 specifies that where dowry is given for the benefit of a girl, that property should be transferred in her name. She should have complete control over the property that is given as dowry. And again, failure to transfer this is again punishable. Now, section 7 is interesting because remember we said giving and taking of dowry is equally punishable and can be visited with even imprisonment. There is a limited immunity that is given to the aggrieved person. So if a wife, a bride, prefers a complaint under the Dowry Prohibition Act, saying that she had given dowry and she was forced to give dowry, then giving of dowry itself being an offense, there is a limited immunity in that there will be no prosecution for her. This can lead to some difficulties because there is no immunity given to her family, right? But again, this has not been such a big problem because if somebody wants to, initiate action against a person who had given dowry, then there should be a complainant who admits to having received a dowry. And nobody wants to make that admission for obvious reasons. But still, in law, there is a bit of an ambiguity in that there is very limited immunity, and theoretically, action can be taken against the family who had given dowry. Section 8A says that burden of proof vests on the accused when it comes to prosecution for taking of dowry. So once there is a case which a complaint where a woman claims that dowry was taken, then it is for the husband and his family to prove that they did not take dowry. So how is the act enforced? And we know that the Dowry Prohibition Act largely is, observed only in its breach. But there are dowry prohibition officers that are appointed, and also there's an advisory board that is constituted under this act. And in the case of Tamil Nadu, the district social welfare officers are designated as dowry prohibition officers in each district, and they are to be assisted by an advisory board consisting of social workers. Now, the dowry prohibition officers have a lot of very important functions, which is, preventive and sort of creating awareness aspect of the Dowry Prohibition Act. They're supposed to hold camps. They're supposed to go and even visit, marriage sites and venues to ensure that there is no dowry that is given or taken. They can inquire into complaints that are made to them directly or which are referred from the police. And they also have to maintain a list of these presents. Now, this is very interesting because, again, this is a rule that is observed only in its breach. There is a dowry prohibition maintenance of presents to the bride and bridegroom rules of 1985. This is a central rule, so is applicable throughout India. And as early as 1985, the subordinate legislation basically said that both the bride and the groom have to maintain a list of presents that were given to them. Both parties should sign this and they should maintain this. Since 2004, there is a rule at the state level which says that the dowry prohibition officers in the state should maintain this list. So within 1 month of marriage, these lists are supposed to be submitted to the dowry prohibition officers. again, observed only in its breach. And I can only imagine that this was supposed to be a bureaucratic sort of response and creating, another level of deterrence for dowry. As early as 1980s, there was an acknowledgement that the Dowry Prohibition Act had not been very successful, and this was observed in the Supreme Court as well. And around this time, there were attempts to also amend the IPC to create other offenses and bring in, stringent enforcement of dowry-related offenses. So the now infamous 498A of the Indian Penal Code was introduced. And here you will see that, any cruelty to a woman by her husband or the husband's family is punishable. And the definition of dowry is not the same as in the Dowry Prohibition Act. So when a woman is subjected to cruelty and harassment with an intent of extracting any money from her, is harassment, is 498A, and is an offense that is punishable in law. There is also dowry death, section 304B, which was introduced as a specific provision, which Amu spoke about earlier. These were very hard fought for laws, hard fought by the women's movements. And dowry death is a provision which says if there's unnatural death of a woman within 7 years of her marriage, and if she was subject to any harassment or cruelty soon before her marriage, such death would be considered dowry death, presumed to be dowry death, making sort of prosecution a little bit easier because there is also shift of burden of proof under the Evidence Act, etc. And this was punishable by 7 years. Tamil Nadu has recently passed a bill which increases the minimum penalty to even 10 years. So I just wanted to end my initial remarks with, how these acts are being enforced and perceived in this day and age. We have laws, we have, over time, sort of progressively increased minimal punishment even. But the reality is that, when it comes to enforcement of these laws, when it comes to taking cognizance of these complaints, law enforcement authorities and even courts are not necessarily allies of, victims of dowry. Police authorities, dowry prohibition officers, and even courts seem to approach this law with the presumption that, this is going to be a false complaint, that, these are disgruntled wives, that's the term that's used very often these days, that they are wielding these laws as weapons and they are preferring false complaints. This is contrary, and again, there is this rising, very harmful rhetoric of how the law is being abused, which runs contrary to statistics really, because we do have statistics which tell us that there is severe gross underreporting of crimes. We have statistics which tell us that dowry deaths are on the increase, number of complaints related to dowry harassment and dowry deaths are on the increase. And of course, conviction rates are low. But given this specific statistic that conviction rates are low, there is a very harmful rhetoric which is perpetuated, saying that therefore complaints are false. But we know that there's a very complex sort of social reason why conviction rates are low. That could be, general failure of the prosecution, biases in the system, right? Women being forced to withdraw their statements, etc. So I'm sure we'll talk about this a little bit later, especially when it comes to 498A. So we now see a trend of courts and enforcement authorities trying to whittle the law rather than strengthen the law, and enforcement is definitely something that's suffering. I'll end here now. Maybe I can take questions later.